Mr. Nasser Issa Fage, who is National President of ASU, in on this matter. Morning, and thank you for joining us. What is the grounds of ASU against the appointment of Professor Fakaye as a Vice Chancellor of Rivers State University of Science and Technology?
Well, the grounds of ASU is just on three issues. First, in 2008, when Prof. Bebe Fakaye was appointed, the appointment was carried out by the visitor in the absence of counsel. And we at ASU are always insisting that we must follow procedure. And our expectation is that if there is going to be appointment of the Vice Chancellor, the council must first be constituted, and the council should be allowed to conduct the selection process, out of which a Vice Chancellor will emerge. Now, at that point in time, our colleagues in RSUST, that's Rivers State University of Science and Technology, protested the appointment. And the visitor, as the Governor of Rivers State, decided to attend the meeting of Congress, where he pledged that this appointment should be allowed to succeed. But they are promising that at the end of the expiry of the first tenure of Professor Bebe Fakaye, he will not get a second term. So that is the crux of the matter. If there is a pledge from a visitor, especially out of respect for the chair the visitor is occupying, our members are pleaded upon to accept, allow that to hold, even though it's not legally right. So what we are saying at us is that first, the first appointment was illegal. Secondly, there was a pledge that it will not be repeated. And now what we are witnessing is that the visitor is going back on his words by appointing Professor Bebe Fakaye in acting capacity.
Okay, then.
I think it's also important to point here that a selection process has already commenced, and the selection process was completed at the level of council, where Professor Bebe Fakaye took the last position out of 5 candidates. Normally, by the rules operating the appointment of Vice Chancellors, the council is supposed to send in 3 names out of the top performers to the visitor for selection. So it immediately became clear that the visitor's favorite candidate is nowhere among the first 3. The process was terminated. That in itself is also a violation of the process for appointing Vice Chancellors as enshrined in the laws of Rivers State University. And also it's a clear violation of the laws governing such appointments as enshrined in the University's Miscellaneous Amendment Provisions Act of 2003. That is what we are saying. And we believe that Governor Amaechi, like any other citizen of the Federal Republic of Nigeria, should be law-abiding, should respect the laws of the Federation, should also respect the laws of Rivers State University. Until and unless the laws are reviewed, we don't expect this thing to subsist.
Let me get...
that's exactly the point we are making. Thank you.
Just hang on a minute. Mr. Williams is here, and I see him nodding in disagreement. I mean, yeah, you disagree with that point?
There's a fundamental misconstruction, misunderstanding. Look, the law is citing is the law that governs federal universities.
Misunderstanding of what? The first appointment or reappointment?
You don't understand the law. In our own law, this is the law. I'll read to you. The law provides in paragraph 6, 2, subject to paragraph 3, that's when you read earlier, above, a person who has ceased to hold an office so mentioned otherwise than by removal for misconduct shall be eligible for reappointment to that office.
There is a problem here. I think that you're relying on the law, but that's not exactly their grounds. Their grounds is that the governor has gone back on his word, that there were some irregularities in the appointment. The first time he apologized and said it will not happen, he will not be reappointed.
That's not correct. That's not correct.
That's not correct?
Yes, that's not correct. Because, look, I was there. At that point, I was legal officer.
Sorry, hold on. I think Mr. Tamuno, I beg your pardon, Fage.
Is it possible for you to get the governor to confirm that it's not correct? This thing happened at a Congress meeting where we have hundreds of our members who are witness. So if he's saying it's not correct, let him, the governor, to come. I will take him with the branch chairperson of that branch. I will also take witnesses to that act.
Okay, can I?
Yeah, okay, hold on, Mr. Fakaye. Well, he says it was actually in Congress, and the governor gave his word in August 2008, I believe. And so they think that, look, he's reneged on his word.
The governor I know will not renege on a promise he makes to anybody. And there's no way the governor will have come out to tell ASU. And he has never in any fora accepted that he would not reappoint Fakaye for a second term.
Well, you say you worked with the university before you left,
of course, yes.
And now doing your private practice. Were you there when he made this?
Look, I am saying that
promise?
I have the records.
Because from the ASU president, he says, well, members were there and they heard the governor make that promise to them.
You also heard the prof that she came in late to the meeting. The governor would not have made such a promise. How will you make a promise that, sorry, I made an error here, I will never reappoint him again?
But there hasn't been any notice to debunk that claim, or has it? Or did we miss it?
No, if you ask the governor, he would tell you that there was no such promise. Okay. Maybe they had what they wanted to hear.
All right, respond to his second comment. He says that there was already a process in place for the selection of a vice chancellor, substantive vice chancellor, after this first term was over. And then that's what the word he used.
Yes.
The governor's preferred candidate was last. And so that was truncated.
Again, the confusion is the consistent comparison of the federal, their own university law to our own law. If you go to the UNILAG law, the procedure is spelled out. You have, first of all, you declare a vacancy, you advertise, then you set up a search committee in case there are people who are qualified to contest but don't want to contest. Then you now go on to put up the Senate Council Joint Committee for the selection.
Was all this done?
In our own case, the law is simply that the committee will recommend to the governor for appointment. It's not even 3. Now, in our own case, the paragraph 6.2 says that an incumbent whose tenure lapses is eligible for reappointment unless he was dismissed for misconduct.
Which law do you think is superior in this?
No. Look, education is in a concurrent list. You understand? And you cannot at any point weigh the federal government law on universities on our own because it's on a concurrent list. There's no conflict. Sorry, when there's conflict, it means that there is a law that is in conflict between the state law and the federal law. Our university is a private university, in the strict sense of it. It's a university funded by the River State government.
Yeah, but ASU says, we'll get him to talk. He says that, in the notices that they put across, yes, that all those processes, according to their laws, there was an advert, they put up all of those. Did River State see all of those at the time?
No, the entire process was, the governor said it, the entire process was followed. Advert was put forward. Persons applied.
And the River State law also approves of that process.
What I'm saying, in our own law, the entire process is not spelled out. Unlike what obtains in the University of Lagos law, University of Calabar law, the process is spelled out step by step, procedurally.